Well, folks, this is a document that was filed on the 23rd of this month. Sorry for the delay. There's also 3 documents filed today. I will be reading those after this. One of them are 42 pages long. The other ones are like 3 and 5 and like 2. But decision and order granting motion to compel. Lawyers and journalists compromise perhaps approximately 2 of our country's most respected professions. This order concerns efforts to enforce a subpoena against a person who, at different times, has served in both roles. And it is a combination of those roles that gives rise to current dispute. A federal district court is empowered to compel production of materials responsive to a properly issued subpoena. The wrinkle here is that the target of the subpoena in question, respondent Michael Griesbach, who also appears to be one of plaintiff Andrew Colborn's counsel of record, defendant Netflix Incorporated asked respondent to produce documents related to the journalistic work, which concerns the events underlying this case. Respondent has flatly refused, initially based on a number of written objections and more recently based on Wisconsin Statute 88514, Wisconsin's reporter privilege statute, pending before the court in Netflix motion to compel, which asked the court to order a respondent to produce responsive materials. At a June 14, 2022 hearing, the court concluded that the respondent's objections were unavailing and granted Netflix motion to compel. The decision supplements the court's prior ruling. Background. Today, respondent Michael Griesbach is one of the 3 lawyers acting as counsel for plaintiff Andrew Colborn in this lawsuit. In his capacity, respondent electronically signed the latest complaint, which accuses defendant Netflix Incorporated, Crow Media, LLC, Laura Riccardi, and more emails of defamation, negligence, and intentional infliction of emotional distress in connection with their portrayal of Colborn in the popular docuseries Making a Murder. Over a decade before Making a Murder premiered, though, respondent was an assistant district attorney in Manitowoc County, Wisconsin, the epicenter of the events giving rise to the aforementioned series. He parlayed this front row seat into the roles as chronicler and commentator. By his own admissions, he became obsessed with the case against Stephen Avery, the titular murderer. He had authored 3 books on the Avery saga: Unreasonable Inferences, Its True Story of Wrongful Creation, Its Astonishing Aftermath, The Innocent Killer, A True Story of Wrongful Conviction, Its Astonishing Aftermath, and Indefensible, The Missing Truth About Stephen Avery, Teresa Halbach, and Making a Murder. He also gave related radio, television, and print interviews, even appeared in the first episode of allegedly defamatory Making a Murder. Because of respondent's extensive involvement with all things Avery, Netflix served a third-party subpoena on him, demanding discovery of documents, communications related in general to the research, drafting, and fact-checking of his books, his communications regarding Making a Murder, Netflix, and producer defendants, and his work on Avery's case during his time as assistant district attorney. Respondent objected to the grounds that the evidence sought did not meet the federal civil evidence 401 standard for admissibility. 2, disclosed would be prejudice plaintiff by turning his attorney into a witness. And 3, respondent had no special knowledge of concerning the evidence in the Avery case, because he had relied on public documents for his research. And 4, the evidence sought was available from alternative resources. He also made clear that he did not intend to produce any responsive documents. 15 days later, he added an objection based on Wisconsin Statute 88514, Wisconsin's reporter privilege statute. Netflix subsequently filed the motion to compel. Legal standard. The information subpoena seeks must not exceed the limits of federal civil laws. Discovery standard. The standard provides parties may obtain discovery regarding any non-privileged matter that is relevant to any party's claims of defense proportional to the needs of the case. In other words, subpoena should be enforced so long as reasonable in the circumstances. To make determination of the court should consider timelines, good cause, utility, and materiality. In addition, a court must weigh the value of the material sought against the burden of providing it. It can take account of society's interest in furthering its truth-seeking function particular case. Importantly, the objecting party is burdened to show why a particular discovery request is improper. If they cannot, the motion compelled should be granted. Analysis. Respondent objects to Netflix subpoena for 5 grounds. The evidence sought does not meet the federal rule of evidence standard for admissibility. Disclosure would prejudice the plaintiff by turning his attorney into a witness. Respondent has no special knowledge concerning the evidence in the Avery case because he relied on public documents and research. The evidence sought available alternative sources. Wisconsin's reporter privilege shields information sought from his disclosure. Because none of these grounds demonstrates that a subpoena exceeded the limit to Rule 26B or is unreasonable for the circumstances, the motion compelled will be granted. Respondent mistakenly conflates the evidentiary standards of admissibility with the standard governing discovery. Respondent first objects that nothing Netflix has requested would be admissible at trial. This is a classic category error, which is discoverable is not always, indeed does not need to be admissible. The key at the discovery stage, relevance, and the relevance does not turn on whether the evidence sought itself would be admissible at trial, but rather whether the evidence reasonably could lead to other matters that could be bear or any issue that may be in this case. So a party who refuses to respond to the subpoena on the grounds that is nothing produced would be admissible at trial propounds a position no more illogical than a detective who rebutts fingerprint evidence simply because that in and of itself will conclusively identify the culprit. The discovery of the provisions of the Federal Rule of Civil Procedure are applied broadly, liberally, and possible. To allow parties to explore possible leads, respondent has not established that the Netflix subpoena does not anything more. The subpoena does not seek purely public documents obtained from other sources for the purpose of turning respondent into a witness his clients determine. Respondent's second, third, and fourth objections are effectively premises supporting his proposed conclusion that Netflix issued a subpoena in bad faith as part of a strategy that embarrasses him and prejudices his client. If his theory goes, the only documents sought are publicly available, then only reason respect from the respondent and not any other possible sources underhanded gamemanship. Where that is true, it would represent good cause to limit the scope of discovery under federal and civil rules. There is no reason to burden one party's attorney with the task of compelling or turning over documents that already exist in public domain. The problem the respondent is that his argument strawmans Netflix position, selectively ignoring multiple requests for overly non-public information in his possession. For instance, respondent complains that he should not be required to respond to the subpoena seeking copies of his books when the books are in print and publicly available. But the subpoena does not simply request copies of the books, rather it seeks documents drafted in connection with the books, documents and communications consulted, relied upon, sent, received, or used in writing the books, documents and communication regarding drafting, editing, fact-checking of the books, and documents and communications regarding marketing and promotion of the books. Respondent asks the court to take him at his word that even these related documents and communications are publicly available, but there's nothing to see here is not a valid defense to properly issued subpoena. Holding that even an expectation of the fulfillment of the insufficient to justify cutting off a party's discovery rights. Nothing that would be improper to deny motion and compel based on the bare representation that the deponent knew nothing about the case. And there's a little footnote because respondent was unwilling to negotiate the scope of the subpoena with Netflix directly. The subpoena, as currently constructed, likely does sweep up some publicly available information, but this is not enough for a respondent to prevail. A subpoena is usually just the opening salvo. Discovery asks for too much because he's not, until he's told, aware of the discovery's problems. The respondent cannot refuse to discuss any potentially legitimate problems and then try to invalidate the entire subpoena on grounds that the parties could have been windowed remain broad. This is especially true where this case available evidence flatly contradicts the discovery assertions. As Netflix points out in his book, Indefensible, respondents reference to at least two non-public sources who provided information responsive to the subpoena's second request. In another book, Innocent Killer, the respondent recounts his non-public action as conversations at a Manitowoc County prosecuting regarding Avery's exoneration and subsequent murder conviction. These examples undermine respondents' contention that undisputed that the books are based entirely on his own impressions of publicly available records. The subpoena also seeks documents and communications regarding or related to making a murder. Respondent again claims that there's no such private communications exist, but through a subpoena issued to the Manitowoc County Sheriff's Department, Netflix was able to discover messages that respondent sent from his private email address specifically discussing making a murder with members of the Sheriff's Department. Unless he CC'd the department on every email which he broached the docuseries, respondent is likely in possession of additional private discussions responsive to Netflix subpoena. At the very least, he has not carried his burden to show that Netflix discovery requests were improper. And the fact that Netflix has not sent respondent on an unnecessary scavenger hunt cripples his argument for bad faith. It is one thing to burden an attorney with needless discovery, or a presumption of impropriety might follow from that. But no special privilege or immunity shields a person from discovery simply because he or she is an attorney or even an attorney for a party of the suit. Attorneys who are fact witnesses cannot claim harassment or undue burden when opposing party seeks discovery from them. The discovery Netflix seeks, while broad, is at face value legitimate. Respondent is not exempt from this simply because, choosing to wear many hats, he has inadvertently taken on a dual role as attorney and witness. The Wisconsin reporter privilege does not apply to reporters who choose to join a party's legal team. Respondent's final argument in the Wisconsin's reporter privilege, confided in Wisconsin Statute 88514, an absolute bar to any discovery related to three books. Unfortunately, the statute only took effect on June 2, 2010, and there is therefore a dearth of case law, actually none, interpreting it. Accordingly, respondent relies on plain text argument, insisting that the statutory text absolutely precludes enforcement of the first 6 documents requested in the Netflix subpoena. Before reaching the substance of the argument, the court must consider Netflix's contention that the respondent waived the privilege when he failed to invoke it in his initial set of objections. The Seventh Circuit has clearly stated that the federal civil rule requires that the objecting party to raise objections before the earlier of the time specified for compliance of the 14 days of the subpoena is served. Here it is undisputed that the respondent first asserted the reporter privilege on March 11, 2022, meeting confer, 29 days after Netflix served the subpoena on him and 15 days after he filed his written objections. Netflix argues that the respondent's untimely objection mandates a finding of waiver, and the record of the court strictly construed Rule 45D to be 14-day entitlement to deem the objecting party's objection waived because the objection came 19 days after the service of the subpoena. And Appleton Papers, the court found waiver where objections first appeared a month after the subpoena had issued. Netflix arguments notwithstanding, courts have not generally adopted such a hardline stance on waiver. For example, in Yusuf v. Samatar, the court held the district court may consider untimely objection to a subpoena. 2020 demonstrates. The Southern District of New York noted that many courts have not viewed Rule 45's 14-day deadline as providing a bar to any later objections based on privilege, and Clint's Court, DuPont de Nemours County, the court excused late filed objections with the delay was not the result of the full willfulness of the bad faith. In this case, the court would be justified in finding a technical waiver based on the respondent's unnecessary delay is raised in Wisconsin Statute Section 88514. But As Netflix acknowledged the status conference held on June 14, 2022, the delay has not caused it any real prejudice. Given the significance of the issue, utter lack of harm to Netflix, the court will excuse any technical waiver. Sorry. Having forgiven respondents' procedural failings, the court now moves to the substance of Wisconsin Statute 88514. It's not so many words. The statute prohibits issuance of subpoenas compelling news persons, a category that undoubtedly includes respondent, to testify about or disclose certain covered information obtained while acting in the capacity as a news person, absent narrow expectations, which provides a disclosure of any another person to disseminate the public views, information, and identity of the source. By news person does not constitute waiver or protection from compelled disclosure. Invoking this subsection, respondent argues that even though he is currently Colborn's attorney, any disclosures he made to Colborn in that capacity did not waive his right to invoke a reporter privilege and defend Netflix. Respondent's straightforward position in subsection 4 clearly says that a disclosure to any other person does not constitute a waiver of protection from compelled disclosure. This means that the news person who shares information with another does not forfeit the right to invoke Section 814. The meaning of the law is clear from the text that the analysis ends. Thus, according to the respondent, the court should find in favor and deny the motion to compel. But this ignores the thrust of the Netflix argument. Netflix has never suggested that a news person who releases certain information to another forfeits reporter privilege. Indeed, this is the whole point of reporter privilege. Holding the privilege extends to unpublished materials that a reporter holds back. Journalists do not generally accumulate information for the purpose of burying it. The nature of the profession contemplates an evidential public disclosure. If such disclosure waives the privilege of undisclosed source information, then the pledge to keep something off the record would carry less weight than the pinky promise. Recognizing the state legislatures across the country have drafted statutes to protect reporters' rights to disclose some information without jeopardizing anonymity of the sources. Reporter obviously cannot waiver her privilege to undisclosed source information, sharing other positions of gathered source information with the public. Publication of articles does not constitute a waiver of the reporter's privilege to refuse to disclose information obtained course of pursuing professional activities. Neither can we agree with the appellant contention of the appellee. By the voluntary disclosure of the identity of the other sources, waive whatever privilege she had. Contrary to the state's contention, publication of the part of the information gathered does not waive the privilege, as all information gathered the same subject matter. I lost my place. Okay. A waiver by newsman applies only to the statements made by the informer which are actually published or publicly disclosed, and not to other statements made by informer to the newspaper. As an entity that itself enjoys the protections of the privilege, Netflix recognizes and supports application of anti-waiver exception. It also clarifies it's not suggesting that by doing his journalistic duty in the abstract, respondent made his notepad a matter of public record. Rather, it argues that the protections of Wisconsin statute simply do not apply when a news person chooses to join a party's litigation team. Doing so implicates concerns separate and distinct from those the reporter privilege statutes seek to address. The reporter privilege is meant to sign the threat of judicial intrusion into the news gathering, and the editorial process therefore support a free, independent press. But freedom of the press is not imperiled when a news person voluntarily joins a lawsuit, and in doing so assumes additional responsibilities of the court and its legal advisory. The Northern District of Illinois has reached the same conclusion in assignment with Northwestern University. In the uncannily similar case, the defendant moved to compel discovery of otherwise privileged material from the filmmaker who had joined the plaintiff's litigation team. The court granted the motion, holding that the filmmaker could not wield the reported privilege on both the sword and the shield to benefit the client, disadvantage to the opponent, privilege of the sword to undermine the defense. Distinguishing the case from Andrews-Nixon, where the reporter's dual role of party reporter required special considerations of fairness. Despite respondents' argument of the contrary, Wisconsin's reporter privilege statute does not arbitrate the border waiver principle. Section 8514 simply does not contemplate the facts of the case. It does not. The respondent appears to claim that his reporter privilege cannot be waived in circumstances. Generally, as a particular circumstance in which, consistent with the free and independent press, disclosure will not constitute waiver. The circumstance identified in Section 8814 is not the situation as presented here. It also does not matter. A plaintiff represents the respondent has never shared unique information with Colborn or co-counsel. The respondent has seen that he has seen and knows what he knows. He cannot compartmentalize the region of his brain responsible for Avery-related news gathering. Thus, when he agreed to act as Colborn's counsel, he inadvertently impaired this knowledge to Colborn's legal team. Having done so, respondent cannot allow Colborn to selectively access and thereby weaponize only the most advantageous facts, while his advisories are denied the access to the left gasping in the dark. This is precisely the kind of situation the sword and the shield waiver doctrine is meant to prevent. The court therefore finds Wisconsin Statute 88514 as not applicable to the respondent's case. As a coda to the discussion, the court notes that it does not know what, if any, responsive documents the respondent has. He refused to engage in negotiations, and it was addressed to the subpoena in only a broadest terms. The Netflix may have cast a net that will untimely come to up empty, but it cannot be thwarted in its attempt. Lastly, the court notes that even the Wisconsin statute, Section 814, applied in the bar discovery as a respondent, Netflix could likely obtain the information from Colborn himself under federal rule. Party may serve any or other party's request with the scope of Rule 26 to produce documents in respondent's party possession, custody, or control. An attorney and an agent, principal, and documents held by agent and attorney are within the control of the client principal. Accordingly, to the extent the respondent possesses the documents related to the issue of this case, those documents are also in Colborn's possession, custody, or control. Because of this, the concerning the fundamental unfairness implicated herein, where Wisconsin Statute 88514 is independent, and the court would reopen discovery and allow Netflix to issue new discovery requests seeking relevant information from his litigation advisory, Colborn himself. Conclusion. For the foregoing reasons, it is hereby ordered that the defendant Netflix incorporates motion to compel discovery. Electronic court filing number 206 is granted. Attorney Michael Griesbach must produce documents responsive to the request. Dated Wisconsin, Milwaukee, June 23rd, 2022. We got three more documents. Two of them are real short, and one of them's a deposition. So I'll be back up in a little bit. Actually, yeah, I'll be back in a little bit.